The first time I heard that my HOA had sold the Greenbelt behind my house, I thought somebody was joking. I had lived in Orange County for 14 years. That strip of open land behind our homes was the reason my wife and I bought there in the first place. It was 11 acres of native grass, old sycamores, a walking trail, and a shallow seasonal creek that ran after heavy rain. Kids learned to ride bikes beside it. Retired neighbors walked their dogs there every morning. It wasn't a private backyard. It belonged to the whole community. Then, on a Tuesday morning in October, I saw 4 white survey stakes driven into the ground beside the trail. Each one had bright orange tape tied to it, and attached to one of them was a laminated sign that read, "Future commercial parking, 86 spaces." I called the HOA office before I even got back inside. The board president, a man named Richard Voss, answered, like he had been waiting for the call. "Oh, that," he said. "The association has entered into an agreement. It's a business decision. The Greenbelt isn't owned by individual residents." I asked him what exactly that meant. He told me a developer had offered the HOA $1, $4 million for the land. He said the money would strengthen reserves and protect property values. Then he said the sentence that changed everything. "You people need to understand," Richard told me, "that looking at a patch of grass doesn't mean you own it." He was right about one thing. I didn't own that Greenbelt by myself, but neither did he. And by the time Anna was done pulling the county records, Richard Voss learned that a board vote was not the same thing as permission, because buried in a deed recorded 41 years earlier was one sentence that made their $1, $4 million sale legally worthless. And it cost them far more than the land they were trying to give away. Our neighborhood is called Canyon View Estates. It sits in the foothills outside Irvine, built in the mid-1980s when Orange County was still full of orange groves. Open hillsides, and developers promising California living in every brochure. There are 214 homes in the community. Most of us have small yards, narrow side setbacks, and a view of either another roof or the Greenbelt. That open space was our breathing room. My name is Daniel Mercer. I'm 51 years old, and I work as a facilities manager for a hospital group. I'm not a lawyer. I'm not a real estate guy. I'm not someone who wakes up looking for a fight with the HOA. Honestly, until this happened, I was one of those people who paid the monthly dues, attended maybe one annual meeting every couple years, and threw the HOA newsletters in a drawer. My wife, Claire, and I raised our daughter in that house. When Emily was little, she used to call the Greenbelt the long backyard. We would walk through the gate at the end of our cul-de-sac and follow the dirt path to the little wooden footbridge over the creek bed. When she went off to college, Claire and I talked about moving somewhere smaller, but we stayed, partly because the house was paid down, partly because our friends were nearby, and partly because every evening, when the sun dropped behind the foothills, we could sit on the back patio and see something other than another development. The board president, Richard Voss, had moved into the neighborhood about 6 years earlier. He was a commercial insurance broker, always in pressed golf shirts, always talking about asset value and long-term planning. At first, he seemed competent. He pushed through some overdue roof repairs on the clubhouse. He got the landscaping contractor to fix dead irrigation lines. He spoke well at meetings. But after he became president, things changed. Every issue became about money. The playground was too expensive to maintain. The trail lights were too expensive to replace. The community picnic was not an appropriate use of association funds. Then, about 8 months before the survey stakes appeared, Richard started talking about our reserve account. According to him, the HOA was facing a serious future shortfall. He said the private road resurfacing would cost more than expected. He said insurance premiums were climbing. He said dues would need to go up unless the board found creative ways to maximize non-essential association assets. That phrase stuck with me. Non-essential association assets. A few of us asked what he meant. Richard never gave a straight answer. He would smile, straighten the papers in front of him, and say, "Nothing is being decided without due process." At the time, I assumed he meant maybe leasing a corner of the clubhouse parking lot for a food truck on weekends. I did not think he meant selling 11 acres of protected open space to a developer. The developer was a company called Palisade Commercial Partners. They owned a shopping center just beyond the east edge of our Greenbelt. The center had a grocery store, a gym, 2 restaurants, and a medical office building. Their problem was parking. The shopping center had been built decades ago, and the city had started receiving complaints about cars overflowing onto nearby streets. Palisade wanted more spaces. Our Greenbelt happened to sit right behind their rear service road. The plan was simple, at least on paper. They would buy the Greenbelt, cut an access road through the old trail entrance, grade the land, put asphalt, install lights, and build an 86-space commercial lot for restaurant employees and gym customers. The board called it a land disposition. The rest of us called it what it was, a parking lot behind our homes. The first official notice didn't arrive until 3 days after the survey stakes went up. It was a 1-page email from the management company, sent at 6:42 on a Friday evening. The subject line read, "Community Asset Transaction Update." No agenda item, no vote date, no public discussion. Just a paragraph saying the board had approved a strategic agreement that would provide funding for future capital needs. It said details would be released at the appropriate time. That was it. By Monday morning, people were furious. Parents were worried about traffic. Older residents were worried about losing the walking path. Homeowners whose back fences faced the Greenbelt were worried about headlights shining into bedrooms until midnight. But the thing that bothered me most was how careful the board had been with their wording. They did not say they were considering a sale. They did not say a developer had been selected. They did not say the contract had already been signed. They wrote it as if everything had been settled. And the residents were simply being informed after the fact. That night, more than 60 homeowners packed into the clubhouse. The meeting room was built for maybe 30 people. Folks stood along the walls, out in the hallway, and through the open double doors. Richard Voss sat at the front table with the other 4 board members. He looked irritated before anyone even spoke. The first question came from a woman named Marlene Cho, who lived near the trail entrance. "Did you sell the Greenbelt?" she asked. Richard answered, "The board approved an agreement in principle for the association-owned parcel." Marlene said, "That wasn't my question." He stared at her for a moment. Then he said, "Yes. The board entered a purchase agreement, subject to closing conditions." The room exploded. People were talking over one another. Somebody yelled that there had been no vote. Another neighbor asked whether the city had approved the parking lot. A man near the back shouted that the board had no right to sell common area. Richard lifted both hands. "Please," he said, "please. Everyone needs to calm down." That did not help. He went on to explain that the purchase agreement was for $1, 4 millions. The developer would pay all grading, permitting, and legal costs. The money would go directly into the reserve account. He said it would prevent a special assessment and keep dues stable for at least 5 years. Then he delivered the line that made half the room go silent. "The residents do not own the Greenbelt," Richard said. "The association does. The board has fiduciary authority to make decisions for the association." I stood up. I had not planned a speech. I was just tired of listening to him talk, like 200 families were an inconvenience. "So, you're saying 5 people get to sell 11 acres that every buyer in this neighborhood was promised?" I asked. Richard looked straight at me. "I'm saying the board has the legal authority to manage association property." "Manage it," I said, "or sell it." His jaw tightened. "Mr. One Mercer, the association is not required to preserve land simply because some residents like the view." That was when I realized this was not a proposal. It was already a deal. And somebody had to find out whether they actually had the right to make it. The next morning, I started with the documents we already had. I pulled out our purchase binder from 2012. It still had the original title paperwork, the HOA disclosure packet, the CC&Rs, and a faded brochure from when the neighborhood was first built. The brochure showed a watercolor image of kids walking beside a creek. Across the top, in big green lettering, it said, Canyon View Estates, a community designed around protected open space. Now, I knew a brochure was not a legal document, but it told me where to look. The CC&Rs had a section titled Common Area. It said the association owned and maintained recreational areas, landscaped entryways, trails, and open space parcels. Then it said the board could acquire, improve, maintain, manage, lease, and convey common property subject to the governing documents and applicable law. Richard had clearly read that part. What he didn't show anyone was the phrase right after it, subject to the governing documents and applicable law. I spent 2 nights reading every page. The CC&Rs were 94 pages long. There were amendments, architectural rules, bylaws, old meeting minutes, insurance documents. I found language saying that major capital improvements required member notice. I found language saying the board had to hold open meetings, except in limited executive session circumstances. But I did not find one clean sentence saying, the board cannot sell the Greenbelt. Not yet. Then my neighbor, Carla Regis, told me to call Anna. Anna Holloway had lived in the neighborhood before us. She no longer lived there, but she had become something of a local legend in homeowner circles. She had spent almost 20 years in title research and land record investigations before opening a small property document consulting business. She was not an attorney, and she was careful about saying that, but she knew how to trace title chains, recorded restrictions, subdivision maps, easements, and old development conditions better than anyone I had ever met. Carla gave me Anna's number. I expected a receptionist or a long wait. Instead, Anna answered on the second ring. Her voice was calm and direct. Tell me what got sold, she said. I explained the situation. I told her the HOA had entered a contract with a commercial developer. I told her the board claimed that residents had no ownership interest. I told her there was no membership vote. Anna didn't interrupt. When I finished, she asked only 3 questions. Do you have the parcel number? Yes. Do you have the recorded CC&Rs? Yes. And has the deed transferred yet? No. The board says it's subject to closing conditions. She paused. Good, she said. Then we're not trying to reverse a sale. We're trying to stop one. The following Thursday, I met Anna at a coffee shop near the county recorder's office. She was in her early 40s, wearing jeans, a navy blazer, and reading glasses pushed up in her hair. She carried a thin laptop and a yellow legal pad with notes already written on it. I asked her if she thought we had a case. She gave me the kind of answer I would come to appreciate about Anna. I think we have questions, she said, and boards that rush a transaction usually rush because they don't want people asking them. She showed me a county parcel map on her screen. Our homes were each separate lots. The clubhouse, pool, streets, and Greenbelt were all separate parcels owned by Canyon View Estates Homeowners Association. Then she zoomed out. The Greenbelt parcel was shaded differently from the rest. See that notation? She asked. I leaned closer. Along the bottom edge of the tract map were small words I had never noticed before. Open space lot A. Anna said, that doesn't prove anything by itself, but it tells us this land may have been created subject to a condition. She explained that when a developer subdivides land, certain parcels may be dedicated for roads, drainage, parks, or open space. Those restrictions can appear in different places. On the recorded map, in a separate declaration, in a grant deed, in a development agreement, or in a condition of city approval. The key was to follow the property backward. We went to the recorder's office that afternoon. The public records room was quiet, fluorescent, and about as exciting as a dentist's waiting area. But Anna moved through it like she had been there her whole life. She pulled the original 1,984 grant deed from the developer to the HOA. Then she pulled the 1,983 final tract map. Then a recorded Declaration of Open Space Covenant and Restriction. At first, it seemed promising but vague. The declaration described the Greenbelt as permanent landscaped open space serving the residential community. It required the association to maintain it. It prohibited certain structures, dumping, and commercial storage. But the board could argue that asphalt parking was not storage. Then Anna found the document that mattered. It was attached as an exhibit to the original grant deed. The paper was old enough that some of the ink had faded. It had been recorded in 1984. When the neighborhood was built, the heading read, "Restrictive Covenant Running with the Land." Anna pointed to paragraph 4. I still remember reading it for the first time. The grantee, its successors, and assigns shall hold Lot A solely as common open space for the benefit and use of the owners within Canyon View Estates. Lot A shall not be sold, conveyed, subdivided, leased for commercial use, or otherwise converted to a non-open space purpose without the prior written approval of not less than 67% of the then record owners of residential lots within Canyon View Estates, and without any approvals required by the city. I read it twice, then a third time, 67%. I said, Anna nodded. 144 homeowners. She said, written approval, not a board vote. Not a newsletter, not a closed-door contract. I asked her whether the restriction was still valid. She did not answer immediately. Instead, she kept reading. That was Anna's thing. She never stopped at the sentence you wanted. She read the sentence after it, and the page after that, because that was where people hid the problem. The restriction had no expiration date. It said it ran with the land and bound all future owners. It said enforcement rights belong to any homeowner in the subdivision, the association, and the city of Irvine. And it said any attempted transfer in violation of the restriction would be voidable and subject to injunctive relief. Anna sat back. Well, she said, that's not a suggestion. For the first time in 2 weeks, I felt something besides anger. I felt steady. We had evidence, not a complaint, not an opinion. Not an emotional attachment to grass and trees. A recorded restriction tied to the deed. And the board had apparently signed a contract without telling the developer or the residents that it existed. Anna told me not to storm into the HOA office waving copies. Documents are strongest when they arrive in a way nobody can pretend they didn't receive, she said. So she helped us prepare a clean, factual package. We included the recorded covenant, the tract map, the original grant deed, and the relevant section of the CC&Rs. We included a letter from a small local HOA attorney that several homeowners agreed to hire together. The attorney, Bria Shah, was careful in her wording. The letter did not accuse anyone of fraud. It did not threaten people personally. It simply stated that the board lacked authority to complete the sale without written approval from 67% of the homeowners and any required city approvals. It demanded that the board suspend all actions related to the purchase agreement until the transaction could be reviewed in an open meeting. It gave them 7 days. It also asked one simple question. Had Palisade Commercial Partners been provided with the recorded deed restriction before signing the purchase agreement? We sent copies to Richard Foss, every board member, the management company, the developer's title officer, and the city planning department. For 3 days, nobody responded. Then, on the 4th day, Richard sent an email to the community. The subject line was, misinformation regarding Greenbelt transaction. He claimed that certain residents were circulating incomplete historical documents that did not override the board's authority. He said the association's counsel had reviewed the transaction. He said the sale was lawful and would move forward. Then he wrote, the board will not allow emotional opposition to interfere with responsible financial management. That email made people madder than anything he had said in person, because by then, homeowners had read the covenant themselves. The language was not complicated. 67%. Prior written approval. Common open space. Not sold. Not conveyed. Not converted. At the next board meeting, the clubhouse was full again. This time, people came with printed copies of the deed restriction. Richard entered through a side door with the association's attorney beside him. His attorney was a polished man named Leon Barrett. He stood near the board table and did most of the talking. He said the restriction might not be enforceable because of subsequent governing document amendments. He said the board was relying on professional advice. He said the agreement with Palisade was not a completed sale and that residents should avoid interfering with contractual negotiations. Marlene Cho stood up again. "Did you tell the buyer about the restriction?" she asked. Leon said, "We are not going to discuss confidential transaction details." She said, "That means no." The room clapped. Richard hit his little wooden gavel so hard it cracked against the table. Then he looked directly at me. "Mr. Fort, Mercer," he said, "you are creating fear in this community over land that you do not own." I stood up slowly. "I don't own it alone," I said. "That's the point. You don't either." For a second, nobody said anything. Then I held up the recorded covenant. This says the board cannot sell it without the written approval of 67% of homeowners. So where are the signatures? Richard's face changed. Not dramatically, not like in a movie, but the confidence left it. He looked toward Leon. Leon adjusted his tie and said, "Again, the legal interpretation of historical recorded documents is more complex than residents may understand." That was the moment the room turned. Not because we had won, but because everyone could see the board had no answer. The following week, Palisade started doing preliminary environmental work near the property line. A crew walked the trail with measuring equipment. Someone tied numbered tags around 2 sycamore trees. My daughter came home from college that weekend. She saw the tags while we were taking a walk. She stopped beside one of the trees and asked, "Are they cutting these down?" I told her I didn't know. That was the worst part of the whole thing. It wasn't just the parking lot. It was standing in a place that had always felt permanent and realizing somebody in a meeting room could decide it was disposable. Anna came by the next morning with more news. The city planning department had responded to the letter. They had not approved the parking lot. In fact, they had not received a complete application. Palisade had submitted an initial inquiry, but the city planner had flagged the open space designation on the tract map. The planner asked the developer to provide proof that the HOA could legally convey the parcel. Anna smiled when she told me, "They have a title problem," she said. I asked what that meant. "It means Palisade may have signed a contract for something Canyon View cannot deliver," she said, "and commercial developers hate uncertainty more than they hate losing money." The next step was simple, but it was important. Priya Shah filed a request for an internal dispute resolution meeting under the association's governing procedures. At the same time, she prepared a lawsuit seeking an injunction to stop the sale if the board refused. The goal was not to rush into court. The goal was to make clear that we were ready. Richard still had one chance. He could pause the sale, disclose the restriction, let the community vote, accept that the Greenbelt might stay exactly as it was. Instead, he doubled down. At the closed-door dispute resolution meeting, he said the board would not be bullied by a vocal minority. Anna was there as a document consultant. Priya was there as counsel. I was there with Carla, Marlene, and 2 other homeowners. Richard looked at us across the conference table and said, "You're trying to sabotage a transaction that protects every homeowner here." Anna opened her folder. "No," she said. "We're asking you to follow the restriction on the deed." Richard gave a small laugh. "A restriction from 1984. Anna didn't raise her voice. "Yes," she said. "Recorded in 1984. Still attached to the parcel today. The same parcel you contracted to sell." Then she slid a document across the table. It was a preliminary title report for the Greenbelt. Ordered through a title company, the restriction appeared under Schedule B as an exception to title. In plain language, it meant Palisade's buyer would take the property subject to that restriction. The developer could buy the land. but it could not legally use it as a commercial parking lot without the homeowner's written approval and city authorization. Richard stared at the report. For the first time, he did not speak. Leon Barrett picked it up and read it. Then he said, "This requires further analysis." Anna nodded. "That's exactly what we've been saying." The meeting ended with no agreement. But the next morning, we learned something that changed the balance completely. Palisade Commercial Partners had sent the HOA a notice of default. The developer's own title insurer had flagged the restriction. Palisade demanded proof that the HOA could obtain the required homeowner approval before the scheduled closing date. The board had 30 days. If it could not cure the title issue, the developer could terminate the contract and seek return of its deposit and reimbursement for certain due diligence expenses. Richard had tried to make this about a handful of residents being sentimental. Now it was about whether he had sold something the HOA did not have authority to sell. That was the moment I knew exactly what Anna was going to do next. Anna's plan was not revenge. That was important. She said, if the board had paused the transaction when we first showed them the covenant, this would be over. The goal is still to protect the land and make the records honest. But protecting the land required pressure, and the pressure came in 3 steps. First, we made sure every homeowner saw the actual documents. The board had been using vague language, strategic transaction, reserve stabilization, association asset. Anna helped us create a 4-page fact sheet. No insults, no rumors, no accusation, just copies of the key recorded language, a map of the parcel, a timeline of board actions, and one question in large print. Did you give written approval to sell our common open space? We mailed it to all 214 homes. We also created a website where people could download the original county records themselves. Every document had a recording number. Every page had a source. That mattered. Nobody had to trust Anna. Nobody had to trust me. They could read the deed restriction with their own eyes. Second, Priya sent formal records requests to the HOA. We asked for board minutes. Executive session minutes were legally available. The purchase agreement, communications with Palisade, the legal opinion the board claimed to rely upon, and documents showing homeowner approval. The management company delayed. Then it produced a stack of records. There was no homeowner vote. There was no signature campaign. There was no written approval from 67% of owners. There was a board resolution approving the purchase agreement by a 3-2 vote. Richard, the treasurer, and one other board member had voted yes. 2 board members had voted no. One of those dissenting members, a retired teacher named Helen Markham, had submitted a written objection. She warned the board that the open space parcel might be subject to restrictions beyond the CC&Rs, and asked that the board obtain a complete title report before signing anything. Richard ignored her. The documents also showed something else. The board had authorized more than $86, 0 inches consulting fees, legal fees, and transaction expenses before the sale even closed. Money from the HOA reserve fund, the same reserve fund Richard claimed he was trying to protect. Third, Anna went back to the county records. She was not looking for a magic document this time. She was looking for context, and she found it in a 1982 Planning Commission file. The original developer of Canyon View Estates had received approval to build the homes only after agreeing to preserve the 11-acre Greenbelt as common open space. It was part of the project's mitigation plan for hillside drainage, native habitat, and neighborhood recreation. There had even been an old letter from the city engineer. It stated that commercial development of the parcel would require a major amendment to the tract conditions and might not be consistent with the site's drainage design. Anna read it and said, they weren't just selling grass. They were trying to undo part of the deal that allowed this neighborhood to exist. We delivered that file to the city planner. This time, the city's response was immediate. Palisade's preliminary application could not move forward without a formal land use amendment. Environmental review, drainage analysis, traffic study, and proof that the HOA had authority to change the parcel's use. In other words, the developer did not have a quick parking lot project. It had a years-long entitlement problem. The sale was supposed to close in 3 weeks. Palisade had been counting on a clean parcel, a cooperative HOA, and a straightforward permit. Instead, it had a recorded restriction, a hostile membership, a city open space condition, a clouded title report, and an injunction waiting if the board tried to force the deal through. The developer terminated the agreement 11 days before closing. It was not dramatic. There was no bulldozer turning around at the last second. There was no courtroom speech. We learned through a short letter sent to the HOA. Palisade stated that the association had failed to satisfy title and approval conditions required under the purchase agreement. The developer terminated and demanded the return of its $175,000 escrow deposit. The HOA had to return it. Palisade also walked away from the project after spending money on surveys, environmental review, legal work, and preliminary site planning. We later heard the company had lost well over $300. 0 inches soft costs and deposit-related expenses. But the real consequences inside Canyon View were only beginning. Richard tried to send another email saying the board had prudently elected not to proceed due to market uncertainty. That lasted about 6 hours. Then someone posted the developer's termination letter online. After that, there was no controlling the story. Homeowners called for a special membership meeting. Under our bylaws, enough owners could petition for a recall vote. Within 4 days, we had signatures from 119 households. People who had never attended an HOA meeting were suddenly knocking on doors, asking for copies of records, and volunteering to count ballots. Richard tried to argue that the petition was invalid because some signatures were electronic. Priya showed him the bylaws. They were valid. He tried to say the board had acted in good faith. Helen Markham, the dissenting board member, stood at the special meeting and calmly read her written objection from before the contract was signed. Then she said, "I did not vote against the sale because I disliked the proposal. I voted against it because I believed we did not have the authority to do it." That line hit harder than any angry speech could have. The recall election took place on a Saturday in the clubhouse parking lot, under a canopy because it was unusually hot. Richard Foss, the treasurer, and the third board member who had approved the sale were all removed. The vote was not close. Richard lost by 143 votes to 48. The treasurer lost by 151 votes to 40. The third member resigned before the final count was even announced. 3 new board members were elected that afternoon. Helen stayed on. Carla Reyes joined the board, and a retired CPA from the north side of the neighborhood named James Porter took the treasurer position. Their first action was to hire an independent reserve fund auditor. That audit found the board had not stolen money, but it did find serious problems. The board had spent reserve funds on consultants without clear member disclosure. It had entered a large transaction without obtaining a complete title review first. It had failed to properly document conflicts and legal opinions. It had used executive sessions far more broadly than the governing documents allowed. The new board recovered some money from the HOA's directors and officers' insurance for transaction-related legal costs. It also negotiated down several unpaid consultant invoices. We did not get every dollar back. Real life rarely works that neatly, but we got transparency. We got a board that had to explain itself. And most importantly, we got the Greenbelt back. 6 months later, the orange survey stakes were gone. The developer removed the tree tags. The city closed the preliminary planning file. The new board installed a small sign near the trail entrance. It read, "Canyon View, Common Open Space, Preserved for Community Use." Underneath, in smaller letters, it said, "Maintained by Canyon View Estates, HOA." That was all. No mention of Richard. No mention of the failed sale. No victory lap. Just the truth about what the land was. Common open space. The new board also made changes that should have existed from the beginning. Any proposed sale, lease, or major change in use of common property now requires a public notice period. A homeowner information meeting. disclosure of all relevant recorded restrictions, and a membership vote whenever the governing documents require one. They also created a digital records portal so homeowners can access budgets, meeting minutes, reserve studies, and major contracts without having to file repeated requests. Anna never joined the board. She did not want the job. When I thanked her, she told me something I have thought about ever since. People think land disputes are about who owns dirt, she said. Most of the time, they're about who bothered to read the promise attached to it. That was exactly what had happened. Richard Voss saw 11 acres behind our homes and saw an asset that could be turned into cash. Palisades saw a shortcut to 86 parking spaces. But the original developer had made a promise when Canyon View Estates was created. The Greenbelt would remain common open space for the people who bought homes there. That promise was recorded. It was public. It had been sitting in county files for 41 years, and the board assumed nobody would ever look. The part that still surprises me is how close they came. If Anna had not known where to search, we might have spent months arguing about HOA authority, reserve funds, parking, traffic, and property values. We might have been divided into people who wanted lower dues and people who wanted the view protected. Instead, the deed restriction cut through all of it. It did not matter whether somebody loved the trail or never used it. It did not matter whether the sale price sounded attractive. The board had a process it was required to follow, and it chose not to. Today, Claire and I still sit on the patio in the evenings. The sycamores are still there. The walking path is still there. When it rains, the creek still runs for a few days, and kids still throw sticks into it from the bridge. Emily graduated last spring. She came home for a weekend not long ago, and we walked the trail together. She looked toward the Greenbelt and said, "I still can't believe they almost turned this into a parking lot." I told her, "They didn't almost turn it into one. They almost forgot who it belonged to." Some people mistake a board position for ownership. Richard learned the difference. The Greenbelt was never his to sell, and once Anna found the deed restriction, neither he nor a developer with deep pockets could pretend otherwise. I didn't want revenge. I wanted the promise attached to our homes to mean something. In the end, it did. If your HOA tried to sell community land without asking homeowners, would you fight it, or would you take the money if it meant lower dues? Some people will say the board should have been free to make a business decision. Others will say common space is part of what residents already paid for. Where do you draw the line? Leave your take below. I read more of these than you might think. This video is a dramatized storytelling narrative based on real-life themes and HOA regulations. Names, characters, and specific locations have been changed. Visuals are generated using AI tools for illustrative purposes only.